All right, let's get started, everyone. So we've got quite a number of new students today. I see a few familiar faces as well from this table. There's one here, probably somewhere here, I cannot remember. But yeah, I hope everyone's doing pretty well, and we are going into week 4, I believe. So we'll continue where we left off last week. But before we get started, I actually do have a few announcements to make as well. So just let me pin myself on Zoom as well. All right. So we do have some announcements as well. So first of all, it's regarding the lesson recordings. There are quite a few people who emailed me and also texted me on lesson recordings accessible on YouTube and the LSS website. You do have to get the membership as well for that. If you don't, you can see me after class and teach you how to access them as well. Second of all, regarding materials, we'll be looking at a few things throughout this term. So first of all, the slides. The slides have been uploaded on the Facebook page all the time before the class. This week I didn't upload them because we are continuing all from last week, but on every Tuesday morning you should see the slides up. I know not a lot of other tutors do this in the future, so don't expect that, but it's just something I do. Second of all, sketch notes and practice questions all available on LSS website as well. That's something you need to know as well. Third of all, unit schedule. All right, so I know that we are just starting criminal law, faculty run criminal law classes today or this week. Who has attended a criminal law class? All right, anyone wants to share with me how your class was like? It's better than 4? Why? In what ways? Okay. All right, perfect. How about somewhere from this table? Anyone wants to share? Yeah.
There's just like a lot of like content. They talk so much, like it's just like they just talk.
They just told them how to talk.
Yeah.
About what?
About like they talk, they have the slides off and they talk about something else. I'm just like I know what's going on.
All right, so we're just helping you to break them down. So what I do is over here, is that I plan to run these classes 1 week ahead or at least on the same week of your faculty. Right now, I'm probably like 1 to 2 weeks ahead of your faculty. But the reason behind this is literally, I want to emphasize something. These classes are not meant to replace your faculty classes. Right? So you guys are here just to learn more, learn additional things, learn how to study, more of studying technique, more of how to read the lectures, for example. So you are here. I'm here because I want to prepare you for your faculty classes. For example, from this table earlier on, 2 minutes ago, I heard this comment of not knowing what to read ahead of class, so I added that into the slides, right? So yeah, for example, you don't know what to read for the first week. You're like, there's so much things, and then how come I read so much and your entire class is on R and Brown? Maybe not. Was it the case? Yeah, whole class on the Brown case, yeah? Pretty much half of it. Yeah, at least that's what my experience is. So basically, I'm just here to tell you, for example, what is important, what is not important, and then you can better prepare. You could treat it as like a pre-preparation session before your every faculty class. It's only like 45 to 50 minutes. Pretty good. Now, one other thing, in-class practice quiz. So yes, I will be running an in-class practice quiz. Probably 20 multiple choice questions. I will think about this. I might run in Kahoot style or I might run in other style. But yeah, there will be a formal in-class practice quiz that I'm going to create in week 6, 2 to 3 p.m. We'll probably spend about 20 minutes revising some concepts. And then we'll look at both, we'll be looking at both sentencing and elements of a crime, which are your quiz 1 and your quiz 2, if you look at assessments. I'll also be giving a top prize, LSS jumper of your choice. So if you're the top prize, you can claim that we can go to the law library together, and I'll make one for you. So yes, do come and do prepare well for that. You guys know what the LSS jumper is, yeah? Like the law school, Monash law school jacket. No? Anyone seen it? A few. Yeah, go check it out. It's at the office. Pretty cool. Yeah, so it's pretty much to show you a law student to flex yourself, maybe. I don't know. All right, finally, PhD tips. What do I want to put this? Oh yeah, people just keep asking me again. So yeah, this brings me back to number 3 again, is that basically these sessions I could theoretically teach you all the content, but that's not my intention because you're going to learn that in your faculty classes, but also at the same time, you are also going to learn the content from year 1 to year 3, 4, 5, 6. So I will obviously cover some sort of like content in class, but that's not my main focus. My main focus is really how do you get the skill, how do you do the best for your exams, okay? One other thing I want to show is regarding your Moodle page. So yeah, one other thing is regarding your Moodle page. So who here has seen this page before? Can I get a show of hands? 1, 2, 3, 4, 5. None from this table. No. All right. Yeah. So again, like if you know my style right now, I'm pretty chill, but I'm heavily focused on assessments. Basically, I'm just here. I'm not the best person to like say learn things much, but if you say how to get 90 WAM, yes, come to me. I'll teach you how to get 90 WAM. All right. So look at this. So we have a 10-mark multiple choice question. This is, I believe, week 6 or week 7, 6 probably. Yeah, probably week 6. So you see, you get 20 minutes to complete. Just let me get the zoom up as well. Yeah, you get 20 minutes to complete 10 questions on what is this? These elements of a crime. On sentencing, right? Sentencing framework. So all the case law that we've learned so far, all the rulings, you need to go and look at them. And then we have another one on elements and principles. So this, I believe, is the elements of criminal law, which is what we're going to look at today. We'll continue from there. Last week and the week before, I believe we talked about sentencing, introduction and sentencing. There might be some sort of principles as well. So it would be nice basically to learn all the content, just like your foundations of law as well. Is it 60 questions, 50 minutes, 20 marks? Same, yeah. So that's how you learn it, right? So you need to have some sort of preparation. Just the only thing is I believe you won't have any multiple choice in that. So I'm preparing you for criminal law in the sense I'm giving you some of these. Written assessments. So written assessment, if you see this, what do we have here? 1,000 words based on topic 1, 3, and 4. Okay, so I believe you early on I said there might be an oral plea. It seems that there is no oral plea this time around. There will be a written assignment. 1,000 words. I doubt they released it. By the way, I can't discuss any of this with you in a sense. I can't open up the document and show you and can't guide you through anything. I'm just telling you when you have assessment, how can you prepare? You need to know things in advance. Okay, so you can't direct any questions regarding the actual assessment to me, and I will not answer any of those, just to make it very clear. But but the thing about this is that you get a problem scenario, right? So this is like those questions that you see under LSS, the practice questions. You will see a scenario, and then you will see 20 marks, and you answer one question. It's something like that, I presume. So that's something we're going to get some practice on as well. Right, so this is your 40%, and then your final exam will be 60%. 60%, pretty much like what I said last week. You have one question on, what was it? Offenses against the person. And then one question on sexual offense. One question on murder and manslaughter. And then throughout these questions, you need to incorporate defenses as well. So this is basically the overview of the entire unit. What we are doing so far until today is the introductory stuff on the elements of crimes and all the principles. And then from, let's say, week 6, probably week 7 onwards, I will not look at the introductory stuff. I will leave the rest to yourself. We'll be formally looking at offenses against the person for 1 week, 1 week, 1 week, 1 week, 1 week for revision, and then week 12 we have an overall revision. Pretty much that's my plan. Any questions so far? No? So each of these will be probably Not confirmed, 20 marks, 20 marks, 20 marks, 40 marks on the slides, 100% of the unit. Okay? All right, good. So, in case anyone is wondering what a problem question looks like, in case anyone is wondering how a problem question looks like, it's something like this. Okay. Still remember this from last week? Yeah. It's regarding the perfect A guy who threw a punch and intentionally causing serious injury. Section 16 of the Crimes Act falls under offenses against the person. So that one over here. Okay, so basically you might get these kind of questions, and then you're supposed to write a 1,000 word essay. Or in the final exam, you're supposed to write a 20-mark essay. But not like this kind of question. Final exam will be these three. Okay. So today we are going to continue about elements of a crime. I don't know why the formatting looks like this, sorry guys. But anyway, so we're looking at elements of a crime. So we start off with the very fundamental idea, where we have this Latin maxim, right? An act does not make a man guilty of a crime unless his mind is also guilty. A bit sexy, so probably a person who might be better in this context. But anyway, so the idea behind is that for you to charge someone, or for the Crown to charge someone with a crime, you need two things. You need AR, Actus Reus, and mens rea. So Actus Reus is what we call the physical element of a crime, and mens rea is the mental aspect of a crime. So, for example, in the case of Daniel, okay, Daniel threw a punch at the faculty for what I can't remember, okay, but he threw a punch at the faculty. So the actus reus is the act of him throwing that punch. The mens rea is the mental element. Okay, was he intentionally doing so, or was he recklessly doing so? Okay, that's the question. For example, just now when I was maybe I was passing the microphone to someone on this table, I accidentally show the microphone on the face of someone accidentally. Okay, then my mens rea will be recklessness or negligence, depends on the context. There is a quite a big difference between recklessness and negligence. We're going to look at that in depth. But basically, in the exam, you're pretty much going to break down what the actus reus is, what the mens rea is, and then after that, you're going to make sort of analysis whether the actus reus has been satisfied, then the mens rea has been satisfied, and then you say, okay, is these of the offenses made up? Pretty much. Questions so far? No? All right, let's move on. So first of all, we're going to look at actus reus. All right, so the physical aspect of a crime. Now, there's a few things we're going to focus on, or a few things that are contentious. So some of the key issues are what we call voluntariness. And then we're going to look at what else do we see? Result crime and conduct crime, so we call causation. These are the two big concepts. Sometimes we're going to discuss omission as well. So let's start off with some of these ideas. All right. So, for example, say for example, let's talk about one scenario. Okay, so for example, this last Friday, I went to what, D1? Was it D1? To drink. I don't drink, by the way. I don't club or anything like that. But for example, last week I went to clubbing and I drank a lot of alcohol. And then after that, I saw someone, I wasn't happy with him. I was intoxicated, okay? I wasn't happy with him. I threw a punch at him. Can I argue that my acts are involuntary? That is one issue, right? Do I have the actus reus? Maybe I was just drunk. I wasn't voluntary, for example. By the way, that doesn't work. But that is one question that you have to consider, all right? So that's voluntariness issue. Second of all is causation. All right, this one I want to think about another scenario. Okay, I'm going to use a scenario that happened to me. So say for example, in December, my car got hit at at the junction or waiting for traffic light. All right. And then after that, the car just got hit, it didn't get written off. And after that, 1 month later, because the car got hit, it can't be locked. And because of that, my car got stolen by another theft person. All right. So then the question is, okay, I'm going to draw a diagram. So there was an initial accident over here. Okay. There was a theft in between. All right. So the third party or the defendant, okay, caused the accident. I could obviously claim for the accident under causation. But because of the accident, the car can't be locked. And because the car can't be locked, after a month it got stolen. The question is, yes, I could sue the defendant for the accident damages. Can I sue the defendant for the theft as well? That's the question. Right. So this is when we look at causation. So later on, for example, in Helen or in Blau, for example, when you cause an injury so seriously to someone that they suffer serious injury and require a blood transfusion, but then the defendant was religious. The defendant did not want the blood transfusion in Blau. So what happened was later on, the defendant or the victim died. Okay. And then the question is, can the defendant be charged for murder? Right. That was another issue. So that's when we look at causation when things like Tin-Skull rule come in play. What I've given you over here, this is actually a tort case. So this tort case, we're looking at another ruling. It's not proving beyond reasonable doubt. It's balance of probability. So that's when you go into learning tort, and you look at contract, you look at damages. That's when you do it. I have to settle that down myself, by the way. It's very annoying. But anyway, so we're going to look at first issue. Voluntariness. Today we're going to have three very important cases. In today's class, I'm going to use cases to discuss key concepts. All right. By the way, I don't expect anyone, in a sense, I don't expect anyone to have look at these three cases. I doubt anyone here has read them. Has anyone read them? No. Yeah. So I'm just going to highlight these three key cases. You're going to see a ridiculous amount of cases later on in law school, but I'm going to make them very simple. Like every week, like the first week or the second week we look at was Crown and Brown, right? So today we look at three cases. These three cases are equally important. So first case we look at is the issue of voluntariness, and we're going to derive some statements of law. So that's something I would do when it comes to a case. I'm just going to explain to you how I structure the delivery of these cases first. So when it comes to a case, what I like to do is, first of all, I have a few lines just to understand the facts of the case, i.e. what happened. These cases are going to run 50 pages. Right? It's a bit too much work. So you write cases, so you probably know. All right, so, and then you're going to think about, okay, what are some of the key issues? Summarize them, and then think about some of the judgments. And then think about, this is a condensed version. Remember in the first lesson we had together, when we talk about Crown and Brown, my slides ran through like 5 slides for one case. Right? So this is a more condensed version, because today we have too many cases. But that case was really introductory, so I spent 5 slides on that. But anyway, we're looking at Ugo and the Queen. So I'm just going to give the class, say, 2 minutes just to read through the facts and basically whatever is on the slides, I'll explain a little bit. All right, 2 minutes, please. All right, I hope you should be done by now. That's the reading speed I expect. But anyway, so we have a very classic case over here, Ugo and Dupuy. It's a appellate case. So when on appeal, basically what happened, two parties, the deceased, i.e. the person who died, and Ugo, the appellant, right? The person trying to get rid of that charge for acquittal. So what happened, two person got into a fight, the deceased and the appellant, right? The appellant, Ugo, was claiming that he was defending himself, right? He was in a very dangerous situation. You want to box me, for example. You want to throw a punch at me. I said, no, don't come to me. Don't come to me. I got a knife over here. And then, but you chose to come to me. So you walk, and you came to me, and you died. That's a knife. And so what Ugo is essentially claiming is that I didn't stab the disease. The disease came to me, and the disease walked to the knife himself. Right, so how can I be charged with murder if I am just holding on to a knife and someone walked on my knife and died? That's essentially the ruling. All right, so basically the question, so he was initially charged with murder, but the issue over here was that, okay, you see the green highlight, did the appellant put the knife into the body of the deceased, or the deceased impaled himself on the knife that the appellant was holding, right? So in the end, what happened was that the High Court said that in this scenario, it was possible for the jury to find that the man did not act voluntarily. Right? He didn't voluntarily put the knife into the deceased. So and the main ruling that you need to know in this case is that a positive and voluntary act, or sometimes see on the summary of PVA, is one which is freely willed and the result of an active and conscious mind. So if your acts are not conscious or not active, then your acts wouldn't be voluntary. This is one of the extreme cases. Later on throughout the semester, I would say quite a fair bit, 90% of your cases will not have too much issue with voluntariness, because they just can't set a 20-mark question if you have voluntariness and then you fail on this aspect. You go on, it's quite hard to set a question like this, to be honest. So, but one of the biggest thing later on, again, at week 12, sort back and stuff, my friends back then, what they do, they say, okay, it's the exam time. I need to write element 1, 2, 3, 4, 5, 6. I learned everything, okay? I'm like you, I learned every single thing. So they wrote an entire case of Google, and then they forgot about the factual scenario presented in that question. What happened in the end, 2.5 hours, they ran out of time. They answered 1.5 questions out of these 3 questions. So what's the maximum mark they could get? 30. All right. But then if you do a very good job, you get 20 out of 30, maybe, or 25 out of 30 if you're very, very smart. And then you see this, then 25 out of 60 you fail. So the thing over here is that you also need to know some exam techniques, right? So you need to know how these are the rulings, but also later on in the exam, all right, don't put everything down. Just know the main rules. But for now, again, maybe it's too early. But for now, know the ruling, and then go and read the cases, have the understanding of self, and then come back to this, and then we simplify again. So the process is pretty simple. It's like, say for example, right now, I'm just going to introduce you. So you read a little bit of it. Then you read the entire 50-page cases. Then back to the exam, you come out with 1 sentence, for example. Sorry for the very poorly drawn background. But anyway, yeah, so that's the idea behind it. Okay, so now let's look at habits. Again, we're going to give you guys 2 minutes. I'm going to discuss that. So this is regarding causation. Right? There are a few rulings in law. This is the lowest prosecution of the but in this case, the defendant is the parent first. The parent is the
Yes.
All right. All right, let's discuss this case. Some of the very good questions came as well. So now, there was one person who was confused about this term. I'm just going to erase this. All right, so there's a few terms that came out. One is deceased. Okay. One is defendant. One is appellant. Or maybe you have the crown, or sometimes you call R, for example. So who is who exactly? So first of all, deceased. Okay, the deceased is the person who passed away. All right. So in this case, is it victim? Yeah, the deceased is the person who passed away, not involved, or the victim in this case. But the victim can't sue, right? The victim has already passed away. But either way, in criminal law, you can't sue. You can't sue as a victim. You can get victim compensation and stuff, but you can't sue. The crown will be suing for you. So the crown will be suing for you. This is the person who prosecute. Right? So that's why you see RV headed or R whatever. So that's the crown. Okay. And then we have the defendant and the appellant. Okay. Are they the same person? No? Yes, no? Who thinks they're the same person? Show raise of hand. Okay, one person here, two person here. Who think the defendant and appellant are different person? You two. What about the rest? No opinions. Soulless person. So okay, now think about this. Okay, so first of all, we have RV Hallett. Hallett is the defendant. Yeah, he was the person to be charged. If Hallett wants to appeal this case, go to the Supreme Court of Victoria or the High Court of Australia. What would be the case name be like? Soft around. Hallett VR. Yeah, so what's the role of Hallett? Appellant. Yeah, so Hallett will be the person who is appealing the decision. So when initially he will be the defendant, he's still the defendant at the appealing stage, but there will be a new named appellant as well. So just be careful. Okay, so you get tested on foundations of law. Are you confused? A little bit? come see me after, or I can explain to you later a bit. Yeah, so let's discuss this case a little bit. This case talks about causation, okay? So what happened was that Helen had beaten the deceased, okay? Very unconscious and left on the beach, okay? It was apparently safe, facing towards the water. So deceased, okay, was unconscious, didn't pass away, but was very unconscious. And what happens, there was a tide, there was a natural force, okay? That, what happened, okay? There was a tide, and then after that, because of that, just let me see. Okay, because of that, the victim died, okay, the victim drowned. And the question over here was that, okay, was the act consciously performed by Helen so connected with the event that it must be regarded as having sufficiently substantial causal effect, which succeeded up to the event, up to the happening of the event, without being spent or sufficiently interrupted by other act. So the intervening act over here was the water, the tide, right? The tide, the act of natural forces. Okay, then the question over here is that enough to break the intervention? You see, in this case, it's quite similar to the case that I happened here as well, right? There was an intervening factor, but is this intervening factor so related that I could touch the defendant for the initial act as well, right? So the outcome of this case, the conviction was held. It was a substantial operating cause, right? Natural forces do, natural events do happen. Sometimes there will be tides. Therefore, even if it was initially we didn't left the defendant in a state where he died later on, I could still say that you caused the death of this person, because but for the defendant or but for Helen beating the deceased until he's unconscious, the deceased would not have died. All right. So the rule over here is that this action must be a substantial operating cause of these injuries. So how would you apply this in the exam? You might have a question. Two persons on this table got into a fight. After the class, they decided to take things outside, and one person beat the other person, and the other person left unconscious. Then this person walked away. The next day, he didn't know that this person actually has a blood disease and passed away the next day, for example. Then the question is, okay, can the defendant be charged for murder? Then one of the issues you're going to discuss is causation. You'll be like, okay, he must prove that these actions were substantial and operating cause, and you start to discuss all the varying factors. All right, so that's the second case. One final case, I believe. One final case for Actus Reus. Blood. This is regarding the blood transfusion. Again, I'm going to give 1 minute. Okay.
It's, you know, it's not always to give it to you. What is that? Doesn't mean that you're suffering. What if the other wasn't like? Yeah, yes. They will participate. Alternatively, if you have No. Yeah. Well, if this person was alive, they yeah. But we still have party. Hey, like, all you can point, like, exactly. That's all I can do, and then you do this, okay. Sure, where's your time? It's not like, you can either manage solution. You know what I mean? I don't know, I just think I try to find people in it. Oh, I'm just trying to say, yeah, refusing the problem. Like, I was in a choice. Like, you're already in, and I could probably be what happens next? What happens? Well, it's a up what it says. The next was by one from the South there. That's been written down to start. Yeah, a big trial. And that was also was not independent of the death. He's saying he is part of it. He had one infinite God. Not taking it one kind of figure was part of that. But that was part of it. He didn't get it. Like that was like, if that meant to be said. Well, that's the law for some. This is pretty funny. Nothing was right. Like even more like we don't know, like okay, but what if you have to deal with it? There's still doing what you think.
All right, let's discuss this case again. Very simply, that was the case that I talked about. Blood show up at the victim's house, wanted to come in, victim refused. Blood stabbed the victim 4 times. Victim was taken to the hospital, required a blood transfusion, but the victim was religious. Victim said, he didn't say that, but like victim's idea was, I rather want to die than to receive a blood transfusion. So what happens? Yeah, died as a result. So what happened? Was Blau's action, can Blau be convicted of murder? That's the question, right? So I just stabbed him. I didn't cause him to be dead, right? But because he did not want to receive the blood transfusion, therefore he died. So that was an intervening factor. You had the victim received the blood transfusion, she would not have died, right? Sorry for that. Yeah, it was a she. All right. So the question over here was the chain of causation being broken? And this leads to a rule, the Bean-Skull rule, which says that a person who uses violence must take the victim as they come. Okay, so these existing health conditions will not relieve of criminal liability. So that's what the Bean-Skull rule is. Okay, so pretty much these are the main causation that you need to think about. Just going to show you a summary page from the LSS slides, from the sketch notes as well, explaining all these rulings. But so far, any questions? Yeah.
If she would have died, if she dies, the guy still.
Charging for it.
Yeah.
Right. So that's when the Bean-Skull rule come in play. So the idea behind this is that people who use violence must take their victim as they find. Some of the victims might have this religious belief that they can't receive a blood transfusion, and the ruling behind this is that it's not unreasonable for someone to refuse a blood transfusion because of religious belief. So therefore, because you were the one who used violence, you must take the victim as they find. So even if later on your victim did not want to receive a blood transfusion and die as a result, you can't say that it's an intervening factor. separate.
So if the victim didn't have like police reason to say they don't want prosecution,
Yeah.
they would still like be still be tried.
And if they die, yes. Yes. All right, so I'm just going to show how this will work in the sketch notes.
Yeah, like, it makes sense, like, you can't, it's like you're saying, well, what if you go to a body, like, when you start from there, you say, oh, well, what if you're like, you should go. But when you have sex, like, you feel like a it should not. Yeah.
Even if the guy was one.
You still start with 45 sex. I don't see why not. So,
But maybe it's.
it's not. It's maybe depending on the context, I don't know. It's a little lucky thing. What if they, despite their beliefs, and gets to kind of or not? Convictions, that's why I'm always very against. The word allegedly is gonna be really powerful. I would be next to the. I mean, I don't know, like this stereotype, like if you're an excellent family will respect it. Just like this vital one. If you're it's easy to have excellent good and bad.
All right, so that's the best I could do over here. So yeah, so if you look at the sketch notes under causation, this is pretty much what we learned today. So first of all, we state the main ruling over here, which is that P must prove that these actions were substantial operating cause of these injuries, and you quote bracket Hallett. That's the first step. All right, substantial operating cause, and then you determine that okay. Is there a novus actus intervenes? Is there an event that broke the chain of causation? All right. So there are a few rules that you're going to learn throughout this semester. You're going to look at things like Royal, you're going to look at Paget, but these are not things that we're going to worry about today. What we looked at today was literally was literally the act of God, right? So I believe that's another one actually. There's a thin skull rule as well, but we're going to look at that in a bit. Yeah, first of all, it's the act of God. So scenario 3 under Hallett, right? So an extraordinary event can sever the chain of causation in very rare circumstances. So in Hallett, it was held that it wasn't enough. Okay, so then so you might want to compare, you might want to read through the case again to really understand why is it that sometimes it can, but in Hallett didn't. Obviously, that would be a discussion on the 50-page case note, not a discussion here. So if you're really curious about the reason behind it, go and look through the case fully. And then secondly, what we also have is we also have the thin skull rule under 2A. Okay, so D may argue that V would not have sustained the injury had they not pre-suffer whatever condition, had they not had this religious belief or whatever. But according to thin skull rule, Blau, any person who used violence must take the victim as defined. And then you talk about these beliefs will not absolve D of existing blah blah blah. So that's like a thing that you could argue in exams pretty much. Okay, so that's how we're going to use that, and then basically that's pretty much all I have for today. And next class we look at mens rea, we look at contemporaneous. Probably do a little bit of mini quiz. Week 6 will be the big quiz. Any questions, final questions? Or any personal issues, come and see me. All right, if not, that's all for today. I'll see you guys next week. Bye bye.